Hello, I wanted to do a quick video to go over one of the issues I'm getting a lot of questions from employers about with the new Families First Coronavirus Response Act, and it's the definition of covered employers. So today is April 14th, 2020. We've had the Department of Labor's frequently asked questions out for some time now. I think the last time they updated those FAQs was April 7th. So we've had some time to digest what they've put out so far. And I wanted to show a few resources and go over a few of these questions about covered employers. So on our website at zallerlaw.com, we've got a resource page for coronavirus with a lot of resources and articles in our past webinars located here, but we've also categorized the Department of Labor's FAQs here. So if you come down to about the middle of this resource page, you can click on View List, and it brings up the FAQs as we've organized it under these certain topics. What I wanted to focus on today were these questions here for the 500 employee threshold and the definition of employer that's covered under the Families First Coronavirus Response Act. So it's question 2, 3, 39, and 50 in the FAQs. And again, these are subject to change. They've been published quickly to give some guidance to employers, but they're not the final say, and the DOL is supposed to be coming out with regulations interpreting the law as well. But I think it's a good guidepost for employers to start thinking about the law and their obligations of their law and if they're covered under this law. So the first question I want to discuss is question 2, determining if a business has fewer than 500 employees. And if you click on that question, it brings up our index, and you can click on the question to expand what the Department of Labor has explained in these FAQs. And again, what we've done is just copied what the Department of Labor has had on their website on the FAQs and just categorize these under the certain topics. And just as a refresher, the FFCRA applies to employers that has fewer than 500 employees. And this, if you're right on the 500 employee threshold, whether the law applies or not determines on if you've had fewer or if you have fewer than 500 employees at the time your employee is asking for leave or the leave is to be taken, then this law will apply to you. And to make the determination and who you count for the 500 full-time and part-time employees, you look at whether it's full-time and part-time employees that work in the United States, and you have to also include all employees on leave, temporary employees, and also employees that are jointly employed by you and another employer. Day laborers supplied by a temporary agency also count, and also I'm getting the question a lot: do independent contractors count towards this 500 employee threshold? And they don't. So independent contractors under the Fair Labor Standards Act, rather than employees, are not considered employees for purposes of the 500 employee threshold. And also getting a lot of questions about the joint employer. If there's two corporations, are they considered joint employers under this test? And the Department of Labor has said they're going to be looking at the joint employer test under the FLSA to see if two entities are found to be joint employers. And it kind of comes down to a quick analysis on that is the control, and if it's common control over the employees and common management, then it's likely to be a joint employer for this 500 employee threshold test. Now with that, the second question I wanted to discuss is I'm getting a lot of questions, and it was a little weird right off the bat. A lot of employers had thought it only applied to larger employers, but the Department of Labor has made it clear it's just applying to employers that have fewer than 500 employees. So private sector employers who have 500 or more employees, the FFCRA does not apply to them. Now, question 39 is a good question, explaining a lot for employers. And the question is, who is a covered employer that must provide paid sick leave and expanded family and medical leave under the FFCRA? So again, the Department of Labor explains that if you employ fewer than 500 employees, you're a covered employer that has to provide the paid sick leave and the expanded FMLA leave under the FFCRA. Now, there is this exception under the law that says if you've got fewer than 50 employees, you may be exempt from the Act's requirement to provide this paid sick leave and expanded FMLA leave. But the question has been coming up a lot, like, well, what do we have to do to get that exemption if we're smaller than 50 employees? And the Department of Labor has set out some other questions regarding this small business exception, and it's set forth in questions 4, 58, and 59. And again, we have links to those here in this Q&A. But the important thing for employers to remember, you don't apply for that exemption. You can't send anything to the Department of Labor to automatically get that exception. You have to maintain documentation showing that if you had to provide the paid sick leave, it was going to be a major stress on your company and would likely probably put your company out of business if you had to comply. And at this point, the Department of Labor is just basically saying you need to maintain documentation to prove that should that exemption ever be challenged. If you maintain that you are exempt and somebody challenges that, you'll have to document that. But right now, there's nothing you can do to apply to get that 50 employee exception. Now, the final question that I want to discuss here for the 500 employee threshold is in question 50. And the question came up here too, is that the FMLA was in existence before this FFCRA was passed, and employers were saying, could we look at the FMLA's definition of employer to interpret this new the new Families First Coronavirus Response Act? And the Department of Labor says no, that definition that's set forth in the FMLA does not apply to this law. So the FMLA's definition of employer does not apply to the Emergency Family and Medical Leave Expansion Act for purposes of the expanded FMLA leave. Employers should use the number of employees on the day that the employee's leave would start to determine whether the employer has fewer than 500 employees for purposes of providing expanded family and medical leave and paid sick leave. And again, the department refers us back to question 2 for more information on which workers are counted towards that 500 employee threshold. So as of April 14th here, that's all the guidance we have from the Department of Labor, and I hope that answers some of your questions. If you have any other questions, feel free to check out our website on the Department of Labor's FAQs. We'll have links in the description below, and feel free to reach out. If you have any questions, please subscribe. We'll be having a lot of videos coming up in the near future. And if you have any questions for future videos, please let us know. We'd be happy to take a look at those and post what we can. Thanks and have a good day.